Good day, everybody. How are you out there today? I wanted to continue the discussion this week that we began last week, where I was talking about some of the misconceptions that guardians and fiduciaries, or just people in general, have regarding care for another person, decision making for another person, etc. First of all, let me thank everybody who participated in our live webinar yesterday. It was unbelievably well attended. The feedback has been fantastic, and I copied a link to the rebroadcast in case any of you missed it. It's up in the corner of your Facebook screen here. So last time I wrote an article, or I'm writing an article called 5 Do Not Make Assumptions of the Guardian / fiduciary / caregiver, whichever hat you consider yourself wearing. Just know that when I talk about these concepts, I'm really talking about all of us who are in a fiduciary capacity, or we are bound, mandated, morally required to take care of somebody else. One of the things that I wrote about, well, we talked about it last week, was this idea that, folks with mental incapacity should be treated, or could be treated, or will be treated like any other illness. So whether you have an ear infection or a broken arm or schizophrenia, you can just go right into the hospital and get a magic pill and it'll be cured. Of course, I went on somewhat long-windedly the other day about this last week, and obviously my answer to that is, come on, we have to be more sensible than that. And I see Kyle has joined. Hi, Kyle. How are you? Good to see you here today. Today, in misconception number 2, I want to talk about one of these big elephants in the room, sort of a giant creature that everybody hides behind. And this is the concept of confidentiality, HIPAA, privacy, etc. And what I wrote, I've copied for you all up in the side of the screen again. Basically, it's this concept that providers cannot receive information from outside parties without a release or without having authorization to do so. And let me just tell you, I cannot imagine, let me just say this emphatically and categorically, I can't imagine a circumstance wherein a provider, especially a medical provider or a healthcare provider, would not want to have historical, accurate, demographic, or histrionic, that's not the right word, but historical data to better inform them of their treatment. Now, I remember back in the days where we would call up a facility, and I'd call up and I'd say, hey, I represent John Doe, and I am John Doe's attorney, conservator, guardian, whatever I may have been. And the patented, or the template that they would use was something along the lines of this: thank you, sir, for calling. I cannot confirm nor deny that John Doe is here. Therefore, I cannot speak to you about his case or any case involving such and such a person. And something along those lines. So they basically said, hey, if I tell you he's here, I'm breaching confidentiality. If I tell you he's not here, I'm breaching confidentiality. So I'm not going to tell you anything. And they wouldn't talk to me. I mean, that was the frustrating thing. And I know that family members experience this all the time, where they're just trying to get in touch with somebody because they have vital information that could really help their loved one. They could really help the doctors or clinicians or psychiatrists or whomever. It could really help them to care for their loved one, and they're very often met with a door slamming in their face. And let me just say here again emphatically, that is just not right. It's not appropriate. There's nothing legal, ethical about it from the doctor's or the provider's perspective that says that they cannot take information. All right. So let's start with this concept of HIPAA. All right. And what does HIPAA apply to? What doesn't it apply to? The original document that became HIPAA, the original thrust of this entire movement, this HIPAA movement, was a federal law that more or less wanted to protect people who were moving primarily from one job to another, And they were leery about having those jobs sharing their medical information for the purposes of insurance or to insure or not to insure. Okay, that was the original purpose behind the Health Information Portability Act. Okay, we have taken that act and we have twisted it all around. We've thrown it up in the air and watched the pieces land. And what's become of it is just become an absolute mess. We've created more of a log jam in an already log jam system because of our insistence that HIPAA applies, HIPAA applies, HIPAA applies. I will say this, up until this year, I have very rarely, if ever, heard of a situation or a case brought civilly for a violation of HIPAA. I've also very rarely, if ever, heard or seen a case brought that was successful, where an award was given for violations of this HIPAA rule. Now, let me say this. I have heard recently that they are trying to extend some of the HIPAA provisions to include doctors who are doing an examination for purposes of whatever, sharing that information someplace else. So if a doctor is, let's say we're in a court proceeding and the court would like a physician's evaluation done, which is very common in guardianship applications and fiduciary applications, the very act of the doctor filling out that physician's evaluation can be seen as a violation of privacy and confidentiality laws. But here's the thing. I'm not so sure that that's a violation of HIPAA as much as it's a violation of the, basic, like I said, basic privacy and confidentiality that you sign with the doctor when you first engage the doctor to treat you. So we have to be aware, folks, that there are privacy issues, there are confidentiality issues. We want to protect those because in our society, we want to encourage people to go to the doctor, tell the truth about what's going on, right? You don't want to be going to the doctor and lying about what's wrong with you, because then how's he going to know how to treat you? So the idea is we want to absolutely be forthcoming and outright and forth with our providers, psychiatrists, etc. That should go without saying. But the idea that I should call up a physician's office as a guardian, as a fiduciary, as a caregiver, or just as a layperson who's concerned about the well-being of a loved one or a friend, and have those people tell me that they cannot accept information that I have is preposterous. There's nothing in the law, there's nothing anywhere that presents this situation where these offices should say that we are not allowed to get information. We're not allowed to hear you. We can't even listen to you. Granted, you can't talk to me, but there's nothing to say that you can't listen to me. And if you listen to me and I give you a couple nuggets that are going to help you out in the care of your patient, doesn't it make sense that you should listen to me? So be very forceful in your role as a fiduciary or as a guardian, caregiver. You absolutely have the ability to give information, not necessarily get it, but you want to give information to help your loved one out or your client. And when you are getting pushback from a receptionist, a secretary, or a paralegal, or a clerk, or whoever the case may be, go above their heads. Go to the supervisor and say, listen, I'm not trying to get information. I'm just trying to give you information. And they really should take the time to listen to you. They should empower you to help them and to help your mutual client, friend, benefit, loved one. So I highly encourage you to take that proactive approach in anything that you do. I highly encourage you to be that advocate that your loved one needs you to be, and to really stand up for what's right and to get information across to the people who would benefit from knowing it. So that's all. I think I beat that horse enough for this week, and I will move on. But again, thanks to everybody who took part in our live webinar yesterday, and I put the link to the YouTube video of the replay for you to check out. And be sure to check it all out. At the end, there's a link to a free gift for all of you if you do check it all out. And I will see you on the other side. So until then, stay proactive, stay proficient, and keep changing lives. You're doing great work. And I will talk to you all soon.